the big W, which is wages, obviously. Minimum wage is now $15 an hour. This is actually capped out now for larger employers. In 2023, employers with 25 employees or less is going to increase to 15. So both large and small employers will be capped out at 15 until the law changes again. But that's where it's set to end right now. So not only is minimum wage increased for those employers who have exempt employees who get paid a salary, their salary needs to be 2 times minimum wage. So for larger employers, they're now required to make a significant amount more. You need to review the salaries that you pay your exempt employees to make sure that you're actually meeting that level. And while you're at it, you should also review what their duties are to make sure that they're actually performing exempt duties and that they should not actually be receiving a wage instead of a salary. So that's something that you should look at the same time. The other impact with the minimum wage increase is that if you require your employees to have their own tools, that you are now required to pay them twice $15 an hour or $14 an hour. So you're going to need to just take a look at what your employees are being paid to make sure that you're on track with this. Okay, wages. There has always been a labor code statute that says that if an employee fails to pay wages, that they are liable or could be liable for a misdemeanor, a criminal misdemeanor. I have never seen a situation where the labor commissioner has actually sent one of my clients or a particular employer over to the sheriff's department or the police department or the DA for them to prosecute this as a misdemeanor. I've never seen it happen. That's not to say it's not ever going to happen, but the new law in 2022 is that this is now punishable as a felony. So the intentional theft with the knowledge that you're actually taking money from an employee is now punishable as a felony. So the interesting thing about this law is that it includes independent contractors, and the labor commissioner doesn't have jurisdiction over independent contractors. They have jurisdiction over employees and employers. So I don't know how this new twist to this would play out. But again, it's out there. I would imagine that very, very egregious situations where employers engage in wage theft will be sent to the district attorney's office for prosecution. So we'll see where that goes. Now, the labor commissioner has always had the authority to enforce their awards and judgments by a personal property lien. A new statute now gives them the authority to do that by filing a lien against your real property. Now, this has a little bit more teeth because, of course, if there's a lien on your property, escrow is never going to be able to close the sale of property. So this is a big deal. The thing that I want to point out is that there is individual liability for wage claims. And this individual liability goes back to 2016. And there's been laws on the books since 2016 that owners or managers of the employer have individual liability for wage claims. So going forward, in order to enforce these decisions and awards of the labor commissioner, they are now going to be able to file a lien against your real property, which may or may not be, well, which probably is not in the name of your corporation. So the takeaway for this, for these felony penalties, for these real property liens, is to make sure that you're paying your employees properly. There's no getting around it. The labor commissioner and the California legislature are enacting these laws to make it harder for, I guess, the bad players to get away with what they've been doing. All right. Regarding independent contractors, back in 2019, there was a statute that turned everybody's head regarding the classification of workers as independent contractors or employees. And essentially what that statute did was it made everybody an employee. There were certain exemptions to that statute, and one of them was that trucking companies in the construction industry are exempt from the statute through January 2022. What the new law basically just did is that it extended this exemption through January 1st, 2025. We all knew this was coming. I think that this extra 3 years will give the lobbyists and the legislature time to actually exempt them permanently somehow. Okay, Robin, next slide. Okay, I'm going to call these next two topics, I'm going to call them the big two P's. So the first one is personnel records. Everybody keeps personnel file on all their employees, or if you don't, you should be. So on the screen is pretty much everything you should be keeping in these personnel files. I wanted to just emphasize that what you should not put in these files are I-9s, medical information, court records, investigation records, drug test results, or background checks. All of that should be in a totally separate file. But the law regarding personnel records has changed. Robin, can you go to the next slide, please? And it used to be that employers were required to keep personnel files for 2 years. You're now required to keep them for 4 years. And I would think that best practice anyway, employers keep personnel files for as long as the employee is employed with them, and then for at least 4 or 5 or 6 years afterwards. A reminder is that personnel files are not the same thing as time records or payroll records. There is a separate law regarding those, and those are required to be kept for 3 years. However, I recommend that you keep those records for at least 4 years, because the statute of limitations for any type of wage claim is going to be 4 years. So keep those records, because the employer is always going to have the burden to prove that they have properly paid their employees. All right. The final P, the second P, of course, is public works. New labor code section that actually now defines what the term monthly means. And you can read that for yourself. The big thing regarding this is that there are now penalties that are immediately given if an employer fails to electronically file their payroll records. In the past, what the DIR needed to do for those employers who did not comply with this was that they had to open up a civil wage and penalty assessment case, which is very time consuming, and it goes on for months and months and months. So the passing of this particular penalty, it allows the DIR to immediately penalize these contractors, and it puts everybody else on an even playing field.